From supplementary list, item number 1.
Lordship, with your Lordship permission, can I mention a matter?
Yes.
Sorry, Lordship, I want to mention a matter that is coming up on 19th of August. This is arbitration appeal number 1 of 2024. Lordship, I'm seeking hearing of this matter tomorrow. The urgency is that the Learned Commercial Court, the executing court, will be releasing the award amount in favor of the judgment debtor, pending the present appeal. This is a section
No, madam,
37
yeah.
of Pardon, Lordship.
What is the urgency?
Lordship, the urgency is that the executing court on 8th of August will be dispersing and refunding the award amount deposited by the judgment debtor to the judgment debtor, pending the present appeal. I'm seeking a hearing on the application that I have filed. The actual matter is coming before your
Is it-
Lordship on 19th of August.
Commercial division. It's a commercial division.
Please.
What's the matter for the other bench?
If it can be taken up tomorrow, your Lordship, because the executing court is listed on 8th of August, day after tomorrow.
Yes, tomorrow before. Yes. Yes.
Lordship.
From supplementary list, item number 1.
Wait, please, Your Lordship. I beg to make a mention of listing 1 at end of the board. Some urgency is there, Your Lordship.
What is the urgency?
I'm praying for interim protection, Your Lordship.
For what?
We moved an anticipatory bail application yesterday. However, we moved an anticipatory bail application yesterday before the single bench. However, the same could not be taken up.
No, that the matter has been specially ordered.
Your Lordship, but some interim protection. I'm asking for some interim. I'm only praying for some interim protection, Your Lordship.
No, it's not possible. When is it postponed here? You mentioned before the other bench, because bench has been specially constituted in a, where my brother and Justice Bhattacharya is sitting. Mentioned.
Hello.
Because I don't have time. That is the reason why I constituted the bench. Yes.
May I please, Your Lordship? This is a supplementary item number 1, my Lord. This is a PIL, my Lord, where I file in my personal capacity, my Lord. My Lord, going by the illicit use and circulations of the single-use plastics, my Lord, which is having an adverse impact on the water bodies and also on our environmental issues, my Lord. I am praying, my Lord, let this matter be admitted, my Lord, and let there be...
Please on the other side.
Lordship, I am appearing on behalf of the respondent number 1, the state.
For the municipal.
You take, we'll post the matter next week. Give the instruction. Post the
My
matter on.
Lord, obliged.
Pleasure.
Post on 14th. 14th. Post on 14th.
Obliged.
Two wives. Second wife. That's the yesterday dictated. No? Post for orders on 14th. Actually, reserve orders. Huh? Orders reserved. To be heard.
Obliged.
Item number 2.
Dictate to the order yesterday. The second executor in having. He has been discharged from service. Yes.
Yes, my lord, in this case, on 7/3/16, Customs Headquarters Shillong made seizure of 4 trucks along with goods, battle of 55 MT, while in transit from Silchar to Guwahati. The Commission of Customs have made order for confiscation of the goods and trucks. Consequent upon confiscation, owner of the goods and truck owners filed the appeal before the sister, Kolkata, and appeals were rejected by the order dated 23/3/18, Annexure 3, 43/45.
Take notice, Mr. Mosque.
I'll file affidavit. Much obliged.
Item number 3.
Your Lordship, please. My apologies for not appearing physically today. I appeared in for the petitioner. I am aggrieved by Your Lordships the demand of tax that has been made on 8/2/2021 by the Superintendent of Taxes, as well as the order passed.
So we are not able to see your face.
I'm sorry, Your Lordship, am I visible now?
Yes, yes.
Yes, my apologies for that. I am the.
No problem at all.
I'm sorry, Your Lordships.
The only thing is, even if you are invisible, we want only to hear the voice.
I'm so sorry for that. I'm so sorry for that.
Yes.
Your Lordships, I am filing this writ in terms of 2 orders. One is a demand of tax which has been imposed on 8/2/2021 by the Superintendent of Taxes, And the other order is 26th of April.
Yes, I've been noticed. Take notice. Yeah.
Lordships, I'm also requesting for a stay because, there'll be no...
No. Let the notice.
At least no
Apart from that, there is no
cohesive
stay.
otherwise-
Apart from that, there is no stay petition before the court.
I have
Yes.
an interim order that I have already placed for your Lordships in the prayer clause.
So it has not been number. See, number is 259, 264. There is no interim application before the court. See the court list. Yes.
I'm grateful, your Lordships.
Yes.
Item number 4.
Item 4.
Would we are challenging the
The rules are
amendment?
challenged.
Yes, ma'am, the amendment.
Notice.
3 weeks time, Your Lordship.
So just one observation, my lord, that whatever existing rules as on today, my lord, the promotion should continue as per the rules, my lord.
Lordship, they have
Basically,
challenged the rules, so they cannot say that promotion has to be done
Yeah,
according to
yes.
rules, Your Lordship.
But
That
all-
rule is unchallenged, Your Lordship.
All I'm seeking for
This is not a promotion.
yes, my lord. All I'm
So
seeking
is there
for
any
is,
promotion will be subject to the result of the writ petition?
yes, my lord. Yes, my lord. It should not be a bar, my lord.
Lordship, because the rule has been amended, Your Lordship. Amending the rule, Your Lordship.
Amended rule
that
will be
is
challenged.
the
He'll say,
prerogative
but
of
any
the
rules have been challenged. There is no question of staying the rules, sir.
Yes.
Yes, notice, yes.
My lord, what I'm saying is, my lord, as per the amended
Yes,
rules,
next.
as per the amended rules, my lord.
Item number 5.
Deeply.
May it please your Lordships. Lordships, we have filed another affidavit regarding the issue of the stray dogs, your Lordship.
Lord, I'll require more time to file my report, my lord, on behalf of the municipal, my lord. Respondent number 5.
The zoo.
The zoo has, well, we had filed the affidavit of the last
We
day.
went and saw the place.
Oh, yes, your Lordship.
Went and saw the place.
And this is
And
regarding...
some of the animals have been shifted. Birds have not been shifted.
Yes, the birds are yet to, because the cages are not yet ready. And one pregnant deer was not shifted because it's not allowed as per rules, your Lordship. And regarding this, we have filed regarding, under
So they will file a report. On the request
the
of
municipal
also-
board can file a report, your Lordship.
Yes, the request of the respondent to file a report. Post the matter on so and so date.
Oblige, your Lordship.
From supplementary list, item number 1.
Eighty-one 18449 is the judgment.
My lord.
Soprakash Rekhi. So it's coming up for admission, no?
Listed for admission, my lord? Yes, my lord. And there is also one judgment which I wanted to place, where my lord has passed singly sitting as a judge in High Court, where my lord has said, if you have not claimed the interest, then interest is not a matter of right. And you cannot gamble with the judiciary system. Because here exactly what is happening is, they keep on fighting for the gratuity, and all these 15, 20 years, they were completely silent on the interest part.
You
Suddenly,
have not mentioned anywhere about
No, not a
Where is the
single
Madras
word.
High Court order?
my lord, WPC, we could not find in SEC online, so we could from Madras High Court website, my lord. It is court, and the authority has got powers to condone the delay, but demand of interest is not a matter of right if a person sleeps over the issue.
But the Supreme Court has taken a different view.
Taken,
Recently also, the Supreme Court has taken a different view
My
on directed payment of 18% interest.
my lord. Let it come for admission hearing, then my lord will go for a fair, because so many, yes.
You refer to the state of Kerala's Padmanabhan case.
Yes.
Do you have the judgment of D.D. Tiwari?
Didi Tiwari, no, my lord, I don't have.
Malad, I have.
Tiwari.
You have.
Malad.
Yes, yesterday I took out the judgment. 2014 8 SAC 814.
Malad, we had filed it is enclosed in the affidavit. We had filed the application for claiming gratuity. At the first instance, there were two representations for claiming gratuity. On the strength of the VRS scheme that was mooted out. Malad.
Where is your application before the controlling authority?
We have annexed it.
Where is it?
Page 170, my lord.
170.
Page 170. And this application itself was filed after a delay of 5 years, my lord.
The authority has condoned the delay. That is right.
Yes.
Authority has condoned the delay, then unfortunately you have filed a review.
My lord,
There is no provision.
no, we have filed the review, my lord, because this petition was heard without us, my lord. Therefore, there is a judgment of single judgment.
Heard without?
It was ex parte. It was heard ex parte without us, without
You
hearing.
were party to the proceedings.
We were partying. No
You
notice
did not
was.
have appeared. You would not have appeared.
My lord, no notice was issued to us. Therefore, then even there is a single judge order, page 188, my lord, page 188. May I read, my lord, page 188. Heard Mr. K. Khan, the learned counsel for the petitioners, as Mr. So-and-so, the learned senior GA.
See, this is first one. The order of the controlling authority was challenged by way of a writ petition. In the writ petition, the matter was directed to be taken up. Whereas you have preferred a review straight away. So both are different. You must understand.
Yes, my lord. My lord, when the controlling authority.
See, there are judgment which says if the delay is condoned,
Yes.
appeal is not maintainable. If you say the other book,
Yes.
what is it? Universal law book. If you say the other book, it is appealable.
Appealable. Yes.
Appealable. There is a judgment of this court, judgment of Madras High Court saying that any order passed by the controlling authority is appealable.
Yes, my lord. That is, and I think it is V. Kosal Ram. The case of V. Kosal Ram, my lord.
So it is an appealable. So you should have preferred an appeal,
Appeal, my lord.
get the order set aside, or ex parte order, you should have filed a writ petition. Though writ petition is not maintainable,
Maintainable.
however, the learned judges entertained.
Yes.
It's a very categorical finding
Yes.
of the judgment of the Madras High Court on several high courts that when there is an appellate remedy under section 7(7), it is mandatory on the part of the employer to deposit the amount and thereafter prefer an appeal. In order to bypass remitting the amount, you are coming by way of writ petition.
No, the way of writ petition, it is.
But in your case, you are not filed a writ petition.
No, we are not the one who filed a writ petition. It is an appellants who filed a.
No. Appellant has filed a writ petition challenging the order in review.
Yes.
But you have preferred a review, not filed a petition.
Yes.
And thereafter the matter was remanded to the controlling authority to take the matter afresh. That is not the
Afresh.
case.
Yes, my
But
lord.
if you read page number 189 or 88, it says writ petition has been filed. Pursuant to the orders of the court, the matter was taken up by the controlling authority.
Yes.
See, anyhow, you will take up the matter on Monday.
My lord.
If I file, we'll pass orders.
My lord.
Anyhow, you have got a judgment of the Madras High Court.
My lord.
Whether we'll see whether it has got a persuasive value.
My lord.
So it is not just Vaidyanathan judgment, it's Madras High Court judgment.
My lord, because I wanted to borrow some words from my lord if it was to be argued today. Anyway, my lord, Monday.
In fact, my lord, there are recent judgment also. There are recent judgment which I'll be citing, my lord.
Where is it? Give the list.
I'll be giving the list.
Give the list, we'll go through
All
it.
this. Where it is clear category mentioned about the delay in the payment of gratuity. Court has passed the order for delay in posting an interest.
There is a word,
My lord,
either in the application
my lord.
or before the appellate authority, or before the writ petition, or in the writ appeal, or before the Supreme Court,
From court, yes.
mentioning about
Interest.
interest.
My lord, the only thing is that at the time when the single bench has passed the order, setting aside the order of the review, at that point of time, direction was given to pay the gratuity under section 7. The section 7 cannot be read in part. The proviso of the section provides the interest. The interest.
So you say a harmonious reading of section 7 has got to be done, isn't it?
Yes.
That's the case. Then you can do one thing. The employer has not paid gratuity. You can keep quiet.
My lord, the only my
You are
lord,
filing a case. Why did you file a case?
the only thing is the matter attained finality only after when the single bench judge had passed the order setting the aside the review order. And thereafter, the litigation, thereafter they preferred an appeal, intercourt appeal was there, and the matter was dragged up to the Supreme Court. So the question of interest rises,
That is not his case.
my lord.
His case is at the threshold,
My lord.
there was a delay of 5 years in approaching the controlling authority.
Yes.
Whether the review is correct or not, assuming that the review is not correct, the pendency of the before the court may or may not be held against him, or they may be responsible for the delay in the matter pending in the High Court,
My lord.
or they may not be responsible for the case pending before the court. As there was a delay of 5 years in approaching the court, even though the controlling authority has got powers to condone the delay,
Right.
whether there should be, whether there is any justification in demanding interest. That appears to be his argument.
Yes.
Correct?
Yes, my lord.
That's all.
And my argument is this, that after the single bench had passed the order wherein it was directed that payment of gratuity is applicable, and I am directed to pay, they are directed to pay gratuity right from the year 2013 till the date when the gratuity amount was paid in the year 2018. I am claiming the interest for that delay part because...
Correct, sir.
My lord.
See, gratuity need not be demanded from the date
My
of
lord.
the order of the court.
My lord.
The interest is liable to pay if the amount is not disbursed within 30 days from the date of cessation of employer-employee relationship. That is what section 4 and 5 says.
My lord.
You will have to work 5 years.
My lord.
One. Number two, the act should be applicable to the employer.
My lord.
And if the employer fails to pay the amount, and after a notice under Form I by you, if they reply or if they don't reply, you are entitled to oppose the controlling authority. If there is a delay, authority is empowered to condone the delay. So all further consequences. When there is a delay of 5 years, which has been condoned, whether interest should be payable or not. So according to you, interest may be liable to be paid after 5 years.
My lord.
Ignore it. Even otherwise, there's 20 years have gone by. You are entitled to get full interest, full principal amount equivalent to 5 years of so what is the prejudice that has been caused to the employer has also got to be seen.
Yes.
My lord.
Anyhow, be ready.
My lord.
We have understood the matter.
My lord.
Don't take adjournment on that day.
No, my lord.
Any reason, saying not well and all.
No, my lord.
We ask your junior or somebody to be prepared.
My lord.
The matter has been heard.
My lord. Monday.
Anything else? You circulate the judgment.
My lord, I'll just...
Circulate the judgment. So Prakash Rekhi judgment, then the 2014 judgment has not been quoted before the Madras High Court.
My lord.
Otherwise, some portion of the interest would have been given. In fact, the Supreme Court has said pay 18%, which is not provided under the Act.
That's what we have complied with the Supreme Court's directions. When we said that we will give, the court said, okay, you
You
pay.
probably would have seen one judgment pertaining to contempt, the Supreme Court. The Contempt of Courts Act said only 22,000 rupees. And Supreme Court says they have got powers to impose more fine if there is disobedience.
Disobedient.
And they were liable for contempt. They can impose a higher amount than 2,000 prescribed under the Act. But of course, contempt of courts, when the High Court order is disobeyed, the powers of the High Court at 215 cannot be curtailed by means of the Contempt of Courts Act.
Yes.
This also judgments are there.
My lord.
Anyhow, you be ready.
My lord.
You also make your junior also to be somebody because opposing out Monday.
Was Monday.
Just 4 more days for me from Monday to Friday.
My lord.
If you argue on Monday, judgment will be on
Tuesday.
Wednesday.
Wednesday. My lord.
Tuesday or Wednesday to be delivered.
Well,
Calculate the judgments.
my lord.